I do want to disclose that we are recording this. If you want to send questions directly to Joe and I and not publicly tonight, you're willing to do that. We're willing to answer your questions that way. If you feel comfortable asking your questions, knowing this will be in the public domain, I just want to make sure you know that and you're not caught off guard by that. So let's get started. See if I can kind of move to the slides here and not get rid of trying to admit people as they come on board. So what led us to offer this webinar? I think what's really been on Joe and my mind is in the 200 and some contracts we've reviewed just in the last 2.5 years, and evolving over the years when Joe would look at contracts for graduating students from the KU midwifery program that I ran for many, many years. We've come to learn that contracts can be a little difficult to interpret, and we believe that's often with intention. I think sometimes, and I watch the student ACNM Facebook page quite a bit. I talk to a lot of people about wanting jobs, and often our fear is that sometimes people will jump into an agreement with A, not even knowing what the salary is or the work expectations, and B, not really focusing on the details of a contract, which often may not be a problem, but for many can be a serious problem when and if you ever decide to leave. So we decided to offer this as an opportunity to share some knowledge and hopefully give you some guidance and learn a little bit more about how to protect yourself. So tonight, what we're going to focus on is why does it even matter? Why can't you just trust your employer that your professional liability insurance is perfectly fine and you're just going to focus on taking good care of patients and reducing liability risks the best way you know how? We're going to talk about types of coverage. Joe's going to take a dive on occurrence versus claims made, which can be confusing, and what do you do with one policy that you would not necessarily have to do with another. We decided, I did a bit of a search today to pick out some de-identified paragraphs or clauses from contracts over the last couple years. 5 case studies we're going to give you of real midwife contracts that talk about the section on professional liability coverage. We're going to give you some of what we believe are effective strategies to negotiate maybe a more shared risk profile in a practice agreement. And then we're going to leave about 30 minutes for Q&A. So that's our plan. And I'm going to turn it over to Joe and let him trade seats with me.
This so far is the most sophisticated trick that we've managed. Let's get going here.
You missed Play-Doh.
That was a transition piece.
It's a pretty good one.
Yeah, I thought it was. You want to go back? Mm-hmm. Ginger wanted to highlight Play-Doh here. I thought that was a fun one. In antiquity, as you probably all know, and it'd be fun for all of you to share what you find, are biblical, ancient references to midwifery, etc., because it is of tremendous value. As we move through, what's going to happen here is, unless I need to jump in, Ginger's going to be answering text chats as I begin to do the dog and pony show here. And we'll get started here.
You're going to have to watch on the right, Joe, to admit people. So if you drag the screen down, there you go. Okay.
We're This is the world's most sophisticated webinar you'll have ever been involved in, including our son calling us at the same time as we're online. Uh, uh, here we go. Professional liability is a necessary element of professional representation of people. Virtually every individual profession has to have some kind of professional liability. Regular RNs are usually covered within the hospital context. Lawyers cover professional liability. What you're hearing about police officers is this qualified immunity that makes them a unique presentation in the professional roles, in that they wind up with their own sort of by statute immunity. So it's a different animal if you want to go that way. And there are two major types of liability insurance, and you'll find that often expressed in these various agreements. The first being occurrence-based policies, which means the policy will pay a claim for medical acts occurring whenever you're insured. And what that basically means is if you deliver a baby, if you had delivered a baby in 2001, and as an adult, they chose to go ahead and file a lawsuit against you, and you left the practice in 2003, that occurrence-based policy will say, okay, we have you covered because the claim arose from when this act occurred, and based on that, this coverage is valid. And as you can imagine, that's not only a tremendous value, but it's also far more expensive. So you don't see people doing the occurrence-based coverage. Now, it's important to understand that like any other malpractice coverage policy, they're usually limited by the person who bought the policy. So if you bought the policy, whatever you do is covered. But in other instances, there's an open question as to whether or not the policy you have that's an occurrence-based policy would cover you if you were in a full practice environment, but also moonlighted sometimes. So someone who offers occurrence-based policy coverage may cover ABC Birth Center, but not cover you when you go out and do something, let's say on a moonlighting arrangement for any other reason. So you have to look at that scope of what is covered and what the activities are within that policy. Then you have the claims made policy, and that's what almost everybody's going to see. This basically says that the policy will cover a payout if a claim is brought against you during the term of the policy. And to me, the easiest way to look at this would be a car insurance policy or a house insurance policy. And let's go with the latter of those two, the house insurance policy. About 2 years ago, we decided we're going to abandon our current homeowners policy. And we're going to move to a new company because they're probably cuter, have funnier advertisements and all that kind of thing. And we began to do that. So knowing what I know about law and insurance and stuff like that, we went ahead and had somebody come and inspect our roof, which is the biggest issue. If you change insurance companies for your roof coverage, for your homeowner's coverage, and then 2 months later find a leak, what's going to happen is somebody's going to come and inspect that policy and say, well, 4 months ago, there was a terrible hailstorm in your area. That is the other guy's policy problem, and you canceled them, so they don't cover it. And since we just started after the hailstorm, we're not going to cover it either, so you wind up paying for your own roof. So they're real thrilled to just continue policies forward, and it's a real boon to the insurance industry to be able to lock in and keep clients forever because they're afraid to jump from one policy to the next. So as midwives move from one place of employment to another, they're changing policies. And they may have the same problem if their practice changes policies and they don't cover this. So if you're running a midwifery practice, it has to do with whether or not You have continuity, and we'll talk more about that here in a moment, of what is covered and what is not as you move from policy to policy. And if you're moving from job to job, the complexities get even more in coverage. What basically happens is if you leave one policy, we call it tail coverage. There is no tail coverage. There is no, once you're gone, you have the whole thing. Not sure what happened with our drawing here.
I don't know who did that either.
I probably did.
But
so you have to look into the structure when you look at this transition. What happens when you leave employment? What happens when you join a new employer? There's 4 basic methods in crafting the employment contract language. The employer assumes all risks of tail policy. The employee assumes the tail policy. The employer assumes the risk, and the employee assumes the risk and can either purchase the tail or secure prior acts coverage, and we'll go to that next, or the contract doesn't say anything. So let's go back over that one more time. Sometimes you have a situation in which your employment contract says, I promise to, the employer says, not only will I hire you, not only will I cover your medical malpractice premiums, but I will also pay for your tail coverage. So I'm covering you for the acts that happened when you were my employee. Why would they do that? It benefits them because they're going to go back and say, we're not going to get sued because of what you did as an employer, or we lower our risk anyway. And we have better coverage for claims that arise later. The second is employee assumes the risk and must purchase a tail policy. We see this in a small percentage of contracts, but what this is a risk shifting situation in which you hired on to do midwifery services for somebody else. They captured whatever, 80% of what you made for them. You're supposed to capture through paying your own insurance policy, tail coverage. And we see contracts that require this on, I'm going to make up a number, but 10 or 15%, in which these employers say, you'll come to work for me, we'll cover your insurance while you're here, but if you leave, you've got to cover our potential liability and your potential liability by paying out of your own pocket for tail coverage. And some of them say that you have to do that.
We've got examples.
Yeah, okay.
I want you to get stuck there.
I won't. Then we have claims-based and tail coverage. Basically, claims policy only covers when an individual act occurs during the term, and tail coverage will make the policy more aligned with an occurrence policy, where the provider is covered for prior acts, even if the old policy is no longer in effect. That's more along the same lines, same theme that we had there. Tail coverage, let's talk a little bit more with some specificity about that. Tail coverage is a malpractice insurance rider or supplement to a claims-made policy that provides coverage for an incident that occurred while the insurance was in effect, but not filed by the time the insurance policy relationship terminated. That is the basic definition, to go back and rehash that, of what a tail coverage policy is. The thing you have to worry about is they sell tail coverage often for a period of time. So I'm an attorney, and you're going to sue me based on 1 or 2 theories of liability, the longest being contract, and that's usually 5 years.
Go on.
Okay. And that 5-year period of time is about the limit to which I'm going to be liable for somebody else. So I've worked on a case for a period of time. They think I didn't follow through with my responsibility. They've got a 2, 3, or 5-year limit. And so if I don't have to buy insurance for anything much more than that. Other policies can cover indefinite or perpetual, but this is kind of how this starts to play out in the OB world. I'll let you just digest that for a moment. The issue about long-term tail coverage or infinite is that you're protected against claims beyond the general statutes of limitations. So I can't remember whether we're going to go into this in subsequent slides, but what you wind up with is the scenario that we're going to wind up talking about is in the OB world, your patient, the mom, may only be able to sue for a short period of time afterwards, and that varies by state all the time. And you have two different kinds of concepts. One, you can sue after the service was rendered, and two, you can sue for a period of time after you became aware you had a problem. But what happens is there's a concept called tolling of the statute of limitations, and that is that if the particular plaintiff has no way to know or can't sue, then they have a period of time in which the statute of limitations doesn't matter. And that would be your minor child. So you have, say, a neurological birth injury, and what you have is somebody, in example number 2, who can reach majority and still has a year or more to be able to file suit on their own behalf. So there is this window of liability when you deliver babies that can go out until the baby that was born reaches majority, and then has a few months in which to cobble together the reality they need to file suit and find a lawyer. So if you take these pieces, if you're moving, then complicate it a little bit more. If you move your practice from one place to the next, you have to figure out what the various laws were at the various locations you've gone from one place to the next. So you have to take the greater of the common denominator, so to speak, as far as risk. It's interesting how many hospitals and other employers require their employees to carry the tail coverage for future claims that may arise. And they do that one of two ways. Again, this is sort of a rehash, either by not providing tails, so you're just left, as it's called in the insurance world, naked, or you're absolutely bound to buy coverage. And we have several contracts that we've reviewed that say you must buy tail coverage. Interestingly, I've never seen a contract that the employer has forced the employee to buy tail coverage that describes how much tail you need. So on the one hand, you could say I could buy a 1-year tail coverage and cut my risks down. And that makes you out of pocket less. But the problem is if you're buying tail coverage and you really need that tail coverage for one of two reasons, you then wind up having the responsibility, you have the risk. And if you don't cover that risk, you still have the problem. And if the contract says you're going to cover tail, there's an ambiguity there as to whether or not, if you get sued 5 years later or 10 years later and you bought a 4-year tail or a 2-year tail or whatever it was, have you fulfilled the contract? And we don't want to have contract disputes because many of the employee contracts say if the employer has to sue you because you failed to follow with the contract and they win, you also owe damages against the for legal costs and the expenses of a lawsuit, and maybe cover them and indemnify them for the liability. And a few states require medical care providers to provide tail coverage as a way to ensure and keep your licensure going. Some states, like Kansas, if you've been within their state required insurance protocols, provide free tail after a period of time to completely get out of this mess. The way you get through this is you check with your insurance provider, your current insurance provider that is covering that policy, to see what kind of tail coverage would happen. And they're usually an additional policy based on your experience there before it expires. And they're calculated on the previous dues, premium dues usually. And some midwives that we've encountered have gotten bids of at least 15,000 or more to cover just 2 years.
Joe, there's a question about what is the period of time in Kansas for tail?
I think we have a slide on that, unless I did.
Not for Kansas. Yeah.
Period of time in Kansas for tail. First of all, midwives are part of the Healthcare Stabilization Fund. If you practice within the Healthcare Stabilization Fund for the required period of time, which I think is something like 5 years.
I think it is.
5 years. I used to be their attorney, but that was 20 years ago. Then they have free tail coverage. So it would be a non-issue. Midwives have been covered under that fund now for about 3 or 4 years. So we're just now getting there. Otherwise, you're looking at the risk management between 2 to 4 years for filing a claim in Kansas. After that, you have the issue of whether or not you should have discovered the lawsuit. And if you wouldn't have normally discovered it, there's a statute of repose that goes out 8 years, I believe. And then you have the issue in Kansas. It's one of those states where up until I think you're actually 20, until your 20th birthday, a 19-year-old throughout the whole time they're 19 will be able to file suit. So it's a matter of dial into taste. But that's as close as I can get. I mean, we're trying to do an overview here. Now the opposite to tail coverage is nose coverage. And in tail coverage, you're usually going to the provider that gave you the malpractice coverage while the policy was in effect. And before that policy lapses, you're asking them to carry forward that risk. But they also understand there's a discount involved because you're not continuing to create new risks. Nose coverage is sort of the opposite, and that's where you go to a new company and you say, I want you to start covering my professional liability practice. So the only way the market can start scooping up new policies is to provide a possibly advantageous price for saying, I'll cover your prior acts for a period of time, 5 years. It's the same game, only backwards. And with this new company, you're then going and asking for previous claims that didn't have anything to do with them. So going back to the roof analogy, you leave State Farm, you go with whatever, Progressive, and Progressive in your policy, you negotiate with them that they're going to cover any damage to storms, et cetera, that was a year before you came to them. So then you covered that gap, that intersection between the two. And you made the new company agree that based on circumstances that exist, there are no existing claims, no known problems. You didn't just deliver and have a bad outcome or something. And they're willing to pick up the risk of those prior acts before you had coverage. So even if it's an occurrence policy, they may be willing to go back. So if someone is in transition between two jobs, or let's make it a little cleaner, let's say you work for a practice and then you decide to start your own practice. If you start your own practice, you either have to figure out how to buy tail on the old employer's policy, or when you go to buy malpractice coverage for your own independent choices, you could say, I want you to cover the last 5 years, which would be probably the most common in midwifery of acts. And you leave yourself pretty well without any idea what the heck you're going to do if you get sued 20 years later. That's not sarcasm. It's like at some point you give up. So in essence, you're doing this intersection between avoiding either by claims based, whether you have tail or nose coverage, and you're trying to figure out how to bridge that gap between the two. And if you're negotiating an employment contract, what we often tell people is try to get tail coverage paid for by your employer. And it's especially a good incentive to say, if you're going to fire me without cause, just because you're done doing business with me, or you're going to close up business, you'll cover tail. If I'm a bad act, I'm responsible for the tail. That's a negotiation position. The reason why a potential employer would want to cover your tail coverage is vicarious liability exists between the employee and the employer. And so if you're independently liable, you're going to start using defenses that say that the practice is the one responsible for the damage. And the practice is going to start using defenses saying you're responsible for the damage. But even if you're responsible for the damage, they may pick up that bill under the theory of vicarious liability. Vicarious liability is just this idea that if I ask you to do something, you go do it. And if you're within the scope of that job that I just asked you to do, the employer is responsible for it. Think truck driver who goes out delivering potatoes and accidentally runs over a baby carriage, whatever scenario you want to use. And that's where you wind up with it, with the employer being responsible anyway. So they have some real value in covering the liability you have so that there's a risk spreading between the policies. And then now the question is, how much insurance is being offered? And we can be quite frank, we really only noticed this with a few unbelievably small policies that have been offered recently in some of our contracts, and all of a sudden we're going, are you kidding? Because you can overread this sort of thing. But we just reviewed a contract recently that offered to cover professional liability to, and you see these two numbers here, $100,000 and $300,000. That's 100 per claim and 300 aggregate per year usually. And what does that mean? It means next to nothing. So let's look at a couple of examples first, and then we'll go back and look at those limits of liability. Here we have a midwife contract that has an example, and the employee shall, this causes the employee to pay for their own liability and therefore the employer's liability for 3 years after they are employed. And this was one actual example we have. So you work for them.
I would just add that the midwife did not understand the burden of what that meant, nor have any idea of what the potential cost of that would be.
And understand, almost all these contracts are at-will contracts. So you might have worked with them for 6 months, but you somehow have to figure out how to cover insurance for 3 years for those 6 months under this kind of agreement. So this is definitely risk flipping for the employer. Here's another one. This one was one of them we just went nuts on in our contract review, and that is, we'll give you professional coverage in amounts and on such terms as we think we ought to. This is absolutely no promise that you'll have any liability coverage. And then whether or not it's so light, like the 100, 300,000, and I think we'll get better to hone that down here a little bit in a moment. And then here's another example. This is more common. This is what we see 80, 90% of the time. And it says you're going to get $1 million coverage per occurrence. It sounds like a lot of money, but that's actually a moderate lawsuit in OB, and 300 aggregate. So, 3 million aggregate. And you start, notice they're being clear here that they're commencing with a start date, meaning they're not going to cover anything before then. And through the term of the agreement, such coverage does not extend to moonlighting, and that the employee And then here we have, upon termination of this agreement, the employer shall provide employee with tail coverage for occurrences relating to services provided under this agreement. This is a problem, frankly, for both the employer-employee, but it's ways much better for the employee. Here, they're promising to cover the tail coverage. If you work for them, you gave them all the money you earned, and you got a salary out of it, they're covering this liability. And it could be easily inferred to at least to these levels, although the contract's not clear. And there is no promise as to how long they will cover, which is to the detriment of this particular employer, because you would have a valid argument if somebody shows up 19 years later. You said you promised me tail coverage. This is what tail coverage is called, and we want to be covered. But this would be one of the, example 3 would be one of the sweetest contracts provisions that we would have. And then here we have
a mess.
Yeah, it's not only ununderstandable. Sorry.
That's exactly how it's written.
Yeah.
You should just
It just sort of goes through, if you go through the mosh pit here, you have.
Start upon expiration, maybe midline.
Where are we at?
Well, maybe not. It intermingles the work with the liability.
Yeah.
It's
this is a hot mess. You not only have the problem of it leading you to believe the employee will be responsible for all insurance coverage, but also for all tail, and then turns around and says, if the agreement is terminated by the employer, they're going to cover tail. I mean, you can see where you can go through this, and in contract interpretation, as a lawyer, you have a problem if the contract says something you don't want it to say, but you are almost in as big of the soup if the contract is so muddled that you're going to wind up suing each other just to figure out what the contract says. And this is a good
part
example.
Of the problem was if the agreement is terminated by the employer for cause pursuant to another section, then the midwife will be responsible for obtaining tail insurance, as to which the corporation shall be named as additionally insured. So if you don't know why you were fired, but you were fired for cause, and you wanted to argue that you weren't for cause, then you'd have legal fees to argue that you shouldn't have been fired for cause, and also have to pay for 4 years after being terminated.
And some of the contracts that we see, one of the 4 cause elements is just more or less a general dissatisfaction of the employer with the employee, which is the same thing as saying firing at will, but they include it within the 4 cause elements for these kind of loopholes. So it takes, we do contract reviews. We don't do deep contract reviews, but we try to hit these highlights as we go through and do contract reviews that are what we do as a fairly nominal fee. We always caution people to get local representation. Here we have an example. The practice shall include your midwife in the self-insurance. This is probably a large hospital or institution, which is going to cover. This 5.2 requires the employee to make sure that they are covering their prior acts with a tail coverage or something like that. And they usually have to prove that. And then, so 5.2 would be your earlier job. You leave ABC company and go to DSF company. And then tail coverage.
And if you can't provide evidence that you purchased the coverage,
they can
you're not going to get hired.
Right. It's a condition to be hired. So either your employer provided tail, again, they're not explaining how much tail you need. If your employer provided tail, then you can get hired. If you go buy a tail policy for anywhere from $0 to $15,000, you can get your job. And then you got to sit down and analyze whether or not you can afford that. You know, can I afford this job?
This next one is the worst.
And then you speak to that. Go ahead.
Yeah. So, and under the tail coverage, what they're saying is, if you're terminated, you have to cooperate with all the necessary documents the practice would want to acquire tail insurance. And if you fail to pay for such tail insurance within 10 days, the practice will pay for the tail insurance that they selected, and that you're going to then have to pay them for the coverage they just purchased for you.
Well, and to spread the misery, the termination of an agreement could be simply the conclusion of the 2 or 3 or 1 year that you had of employment. It could be fired for cause. It could be because they fired you without cause. They hired you, everything's going great, you love your job, and you get called into the office one day. Or it could be because you quit because you had anything from a better job offer to cancer. And all of those apply here because it's just that the agreement terminated. So that's the kind of thing where you go.
So we basically just pulled 5 examples to show you the wide range of what people often think are boilerplate contracts or template contracts, and you just get handed the same thing that everybody else in the country gets handled. You might get handed something closer to a physician contract, and sometimes we even see them that says medical provider, physician, women's health nurse practitioner, and the word nurse midwife isn't anywhere in the contract at all. So, you know, we're not making this stuff up. It's really important for you to know how critically important it is to understand.
And what we hear when people take our contract review and go back to talk to the employer is, this is our contract, take or leave it. This is the same contract we've given to everybody. Oh, we had no idea.
That was in the contract.
Because we just asked Larry, our brother-in-law, who practices law on Tuesdays, to write up a contract, or the office manager is running rogue, and the midwives that are trying to work in a loving, caring relationship with their fellow midwives have no idea what this contract says, because they're the same as the rest of you listen to this seminar. They honestly have no idea. So raising this dialogue is not necessarily an idea of a bad person versus a good person, but it certainly is an open area in which to start a conversation.
So we should go over these just a little bit.
Sure.
These are some things we talk about when we work with people. We strongly advise, if they are not paying tail coverage, for you to have the conversation that you believe they should and why. And that it's actually to their benefit if they do. And sometimes it's just asking the question. If you don't ask, there's no way to know what the answer is going to be. I know in some of the birth centers that Leslie and I consult with, there's this issue of affordability of liability insurance for all the staff and the midwives in particular. And more in the birth center world, I think, than in the hospital owned. Certainly hospitals and FQHCs have their own large insurance funds. We see models where they give tiered tail coverage, which means if you work for me 1 year, I'll pay this percent. If you work for me 2, 3, 4, and if you work for me for 5 consecutive years, I'll cover your tail coverage once you decide that we're done. So asking for that is a negotiation strategy. If they require you to pay tail on departure and they select the policy, we suggest to be very careful about who these people really are. How much trust can you gain from not having a transparent process on a critical professional issue that no physician would agree to? So why should you agree to that either?
Imagine the scenario where you've just walked out from a bad outcome and you're still in the process of trying to figure out why that bad outcome happened, but the employer is concerned enough that it could be you, that kind of idea of you pay tail on departure and they select the policy would be exactly the worst case scenario, because then they go and get an expensive policy for tail, fire you, and you're out the door with a big bill. You just lost your job. You just experienced a bad outcome. And then, and now you're in court being sued to pay a policy you can't afford.
And oh, by the way, they have restrictive covenants in place where you can't practice in your own town within a 100-mile radius.
They're traps that are just unbelievable.
And so you're caught. And the last point here is you should always ask for a copy of your professional malpractice insurance policy. It's nice for them to cover it. It's nice for them to provide occurrence-based, and you can thank them for that and say, for the purposes of my professional files, I need a copy of my policy. You know how to reach the people who broker the policy, and you keep that in your file until you're not clinically practicing another day in your life.
And you know all the rules of that policy. Because another thing that we didn't cover in the slide on occurrence policies is, let's say you have a shoulder dystocia case that comes before you. You've just delivered the baby. That's what happened. Everybody's thrilled. The baby's wonderful. You know, but you then notify your insurance company and put them on notice that there was a problem. That locks in the claim. You got to know everything about that policy, how to properly make notice, etc., yourself in order to keep that coverage. So that's not a tail question. That's creating the awareness of a claim, and you put the company on notice that there's a potential for liability for that claim. So you self-report. And if you don't have a copy of the policy and you're just thinking, I want Myrtle, who runs the front office, to go ahead and handle that for me, you're trusting an awful lot of people for an awful lot of liability for 2 decades. This is the most important slide. It's really important to go through and understand some of these elements, and you probably at this time have left this seminar a little confused on what the heck we're talking about, but to have a really good feeling about what's going on within the contract. And you got 2 stages of risk. One, you just don't even understand the rules of play. And the second is that the rules of play may or may not go your way, but you're dead if you don't know the rules of play. You're at least in the game if you understand what the rules are and then can make your own decisions on what to do next.
So what we're going to do now, I'm going to stop the screen sharing and put this back on a group sharing. And we would love to use this time to talk with you, answer your questions. Feel free to use the mic. We'll try to watch what you're typing in at the same time. And if there are things you want us to repeat or go over again, we're glad to do that. So anybody that wants to jump in, go for it.
Remember to unmute your mic when you ask.
Hi, both. Hi, thank you both for doing this.
We're just a second. Let's turn our.
I think he has to unmute.
I think he's unmuted.
I can hear you.
There we go.
Thank you, Alvin.
Yes, hi. So thank you both for putting on this webinar. I just have a couple questions with regards to male midwives. So we are, in our own practice, we have our own specific issues that I am concerned about. So we buy insurance thinking about probably the worst case scenario that can happen when we're in practice. So my question is a three-pronged question, actually. So when I negotiate my contract with the birth center or hospital system, should I actually increase the amount of sexual harassment, professional liability insurance in terms of aggregate and single claim because of the possibility that this could happen? The second part of the question is in terms of personal tort and injury. If I have a personal injury on the job, let's say a partner doesn't like the way that I'm examining his partner and I get a swing at me, should I actually add personal tort or personal injury into my professional liability insurance? And then number three, should I actually add chaperoning as a requirement into my contract negotiations? And I'll caveat by saying that I do have a business degree and I do have a minor in law. So I actually did follow what you were saying in this webinar. So, but I just wanted to add more clarity and have more an in-depth look into the world of midwifery liability and insurance law as well.
My first question is, who invited you? Let's go with this one step at a time. No, I love the questions, but I think I'm going to lose tracks partway through, so we'll do it in dialogue. The first one, if you have adequate aggregate coverage for the liability purposes, that's going to take care of its own aspect. That's normal professional liability. That means you're within the course of conduct of a professional, but you broke the standard of care, which is different from a gender-based sexual molestation or sexual trespass kind of claim, which molds into your second question. You know, these kinds of professional liability coverages are going to say, this is what happens when I've gone beyond the standard of care, but I'm within the scope of operating in midwifery. You know, it's not going to cover you for a car accident outside the front door, and it's not going to cover you for important, you know, tort claims that come up by sexual misconduct kind of claims. You can do that within the company's purview that offers the malpractice insurance. Malpractice insurance coverage, hell, in the legal world, we find ourselves getting malpractice insurance coverage that also covers cyber attacks. I mean, the insurance company will sell you more stuff. The other way to handle it is something like an umbrella policy if you're a homeowner, and have other coverage that covers you outside against all your assets against claims that come not necessarily just out of the blue, that aren't just in the normal course of conduct of doing business, et cetera. And I can't remember your third one.
Oh, the third question was, should I actually write into my contracts that I would like to be chaperoned in gynecological visits or during examination visits?
It's not a bad idea. The issue then you have to think about is, yeah, you have a preference for being chaperoned, but there are going to be circumstances in which you won't be. And you're better off using an office practice of that being a preference, because you buy into a presumption that you did something wrong simply because you weren't chaperoned. So you have a patient that needs help and nobody else is around except for you, and you're the one that's supposed to help them. You can't not go in. That's a malpractice claim. So yeah, it would be better to handle that as a best practices instead of as a contract provision.
Okay.
It may even be in a policy manual. Sometimes there are references that you have agreed to the policies of the practice, whether that's a collaborative practice agreement statement or policy and procedure manual, an employment manual. And I would say that Alvin, that would be a direct and intentional question I would ask any of your potential employers.
Well, and that's an open conversation that's very healthy, that the employer should appreciate.
Yeah, absolutely.
I practice family law. So, here I am in a situation, you know, you got the classic legendary divorcee and male divorce lawyer kind of risks profile. As I have designed every office I've ever owned, all my conference rooms are full of windows, so I can be inside a conference room talking to a client and not necessarily have anybody with me. My current setup for my personal office, in which where my desk and computer is, doesn't have a window door for a couple of reasons. And first of all, it wouldn't do any good because all you'd see is one corner, but I'll leave the door open when I talk to people.
But he can't do that.
You can't do that.
Yeah.
But there are,
Logical
you
visit.
follow the alternatives of trying to do your best and do those sort of cover without necessarily having documents that say you should have, asked why you didn't,
Mandated that you do.
mandated, you know, those sorts of things. You can say, I'm going to be insistent to have somebody with me, and male OBs do it all the time. They're not going to show up with somebody else in there, and unless they go do an exam with having somebody else. But you're still going to wind up in circumstances where you're going to wind up one-on-one with a patient of yours, and you're doing your best you can to cover them, and you don't want to exclude those opportunities.
Okay, perfect. Thank you. I actually have more questions, but I won't take all of that this time unless someone else doesn't have another question. Thank you. That was a thank you for the information.
I really appreciate the questions, jokes aside.
Other things you guys are thinking about?
Could you just speak a little bit to the liability of going bare or not purchasing that tail insurance if it's something that you were approached as an opportunity to take or leave? When I first came out of school, I was like so excited to have a job. I don't think I even had a contract. I just went straight to it. My best friend Kendra was going to be in the same practice, and we were good to go. And when I left, that's where I was pleasantly surprised. It's not something we really discussed a whole lot about at school. And I did, at the coercion of my collaborative physician, who was an MFM doctor, he said, if you ever want to practice again, just buy it. And I thank him for that, because nobody else really gave me that advice. Even the practice owner was like, yeah, you don't need it. I would never be able to afford buying. So and then coming to Kansas, I ended up taking a non-full scope practice, and they wanted that proof of purchase. So if I hadn't taken it, what risk would I have had as far as ever actually practicing full scope again?
Sure. It's a very, very good question. First of all, just without talking about picking up subsequent work, you're talking about accepting a risk that diminishes over time. And so if you're aware of what's happened in your practice, let's say you've really not done that much OB in the last 6 months, or let's say everything's gone hunky-dory and you've had just a wonderful experience in the 2 years or 3 years that you practiced. You may be sitting there thinking, I don't have that much risk for that big of a check to write. And that's an appropriate analysis. But you also have to sit down and think about the fact, like the person who offered you counsel saying you won't work anywhere else again, is how many employers demand that you have some kind of proof that you've got the coverage that the tail represents. So if that makes any sense. So if you have the coverage that the tail represents, and one of the problems with buying tail is there's often a short window of opportunity to make that decision. You can't quit a job, leave an insurance company, and then wait a year and buy the tail. So as the circumstances change over time, either by your marketability or by your concerns over risk, like maybe you start hearing out in the rumor mill that this kid doesn't act quite right or something, to be rude about it, that's where you wind up with the toughness to the decision. And that's why this tail idea is so important. Now that you're in Kansas, if I heard you right, if you stay in the Healthcare Stabilization Fund as a midwife, I think it's 5 years of participation. For that purpose, you get free tail. That was one of the biggest gifts the Healthcare Stabilization ever gave to what they call healthcare providers. But that's your problem, is you know, this wasn't as hot 10 years ago or 11 or 20 years ago. And so midwives were commonly leaving one practice and just going, to heck with it. And the reason why they're going on to heck with it was midwives weren't considered hot targets by the plaintiffs market. They would be sued along with the employer, but nobody took them seriously as a cash cow. They would be looking for the practice or the hospital or somebody else. They're going for the deep pocket. And so they're going to manipulate their case to where the midwife was there, yeah, but she was poorly supervised, etc. What that led to was a diminishment in the professional view of what midwives did and their limited autonomy.
One thing I'll add in here, if you're not aware, for students or midwives working in National Health Service Corps loan or scholarship repayment programs, those are often covered by federal torts claims, not exclusive, but most are. FQHCs cover through federal torts, as well as Indian Health Services and some federally funded community health centers. So there are a variety of entities where that coverage is comprehensive and provided for you.
Yeah, and those that are covered under some kind of tort claim act, like Federal Tort Claims Act, that means you never had the liability in the first place. So
doesn't mean they still don't review cases. You know,
right.
We were working with some midwives working at an FQHC recently, wanting some advice on how to respond to the question of a potential malpractice case, but it's helpful to know that. So here's a question. Is there any risk of using one of the mentioned options above versus paying for the tail through your current provider?
The only thing that comes to the top of my brain is that if you have two insurance companies, you have at least three opinions on who's going to cover the claim. You know, it's sort of the old rabbi
Pass
joke.
the buck.
And they're going to be in competition between who's going to cover the claim, and they may be in competition on who's going to cover the litigation costs. One of the things we didn't cover in this presentation is an element of professional malpractice insurance is it also covers and there's all kinds of details about this that we could get into in another seminar, but it also covers the lawyer fees to defend you. So you're not standing there one day with trying to figure out if you're going to pay your car payment or the kid's daycare, and then all of a sudden get sued and you got to go hire a lawyer out of pocket. Having an insurance policy in place, you just call your insurance company and they start working on it, kind of like a car wreck. If you have a mix of those liabilities, you do have some vagaries on what would happen. And that goes back to my insistence that if you think you have a claim, self-report that claim, potential claim. This was an outcome that has questionable results. I don't think I did anything wrong, but here I'm going to inform you about it so that you tagged that activity
With a date.
With a date, specificity, whatever they require in their contract to fill that criteria.
Okay. Another question.
I know.
Hi, Sophia. How are you?
I'm good. How are you?
Great. Are you in Oklahoma?
No, I'm in Texas.
Oh, okay, I forgot.
I think this kind of piggybacks onto the what you were saying before about FHQs.
Yeah.
So having retired from the military, that really wasn't a concern, maintaining some sort of malpractice insurance. But transitioning to civilian life now, just considering what would be best, is you mentioned having tail coverage. Now, do I need to be concerned about that? Or is that kind of, because we don't know necessarily what kind of insurance coverage or policies that they have.
You mean in the military experience?
Yes, working within a federal.
Yeah, you don't have any liability. All the liability is covered by the federal government in that context, and unless you're accused of acting completely outside the scope of your role in the military, like Alvin's question about sexual contact and that sort of thing. You get way outside the scope, you could have liability. But if it's just the normal professional liability, your military, that's covered within the military.
Okay, so I shouldn't be too concerned about tail for that.
At all.
Okay, all right. That answers my question. Thank you.
That'd be the same thing that if you were a civilian working for the VA, there just simply is no liability there. There may be other programs that compensate people who are harmed by mistakes, but there's no professional liability in those roles.
There's other examples too, Sophia. I worked at what was at the time the largest free health clinic in the nation in Kansas City, Missouri. And as a volunteer, my professional insurance was covered under the state of Missouri's tort fund. So I didn't have to purchase nor had I chosen, I was working at a hospital at the time, as well as volunteering. There was no need to worry about cross coverage in that situation.
Yeah, those sorts of programs cut quid pro quo is what we call it in law, but they cut a balance between offering services for people in need for limited or no cost. So then they don't have that much to complain about once they get the services. And offering some kind of way in which there's a streamlined way to be compensated if there is a mistake. They acknowledge that mistakes might happen. You get that. But then remove from those people who are participating in those programs as patients the right to go out and do the lawsuits as we do in an environment that is almost the opposite, in which both parties come to the table for a business decision, and the care provider that's offering services, and it goes back to the medical model of your docket with their own practice, et cetera, for profit. And so doc makes immense profits over time doing services, and once in a while may take a hit because they made a mistake, because everybody makes a mistake once in a while, and of that, a small proportion of those become lawsuits. And it's just the cost of doing business. Well, they distilled that and sort of worked it around when you come to these kind of federal programs like you're involved in.
Well, thank you. Appreciate it.
There's reasons why some of you are on here. Anybody want to talk about concerns or what they're curious about? Or are you just on for learning? Alvin's being so patient.
I just want to take up all the time, but I do have some other questions, but I don't know if it'll be of interest to everyone. But
we're here for another 25 minutes if people want to ask.
And I notice Emily has a question that we'll get to after we talk to Alvin.
Okay.
Oh no, Emily can go ahead. I don't know. My questions are always extensive, so maybe Emily should go first. I'm sorry for everyone's time.
Emily asked, are there things you can do for your personal financial situation that protects your private assets?
Good question.
It is a good question, and it deals state by state in what you can do. And then, as we advised Alvin, there's this idea of having additional coverage that cover over your assets, like you have a homeowner's policy. So what many people recommend, if you're involved in any kind of professional endeavor that creates other risks, is that you get an umbrella policy. And an umbrella policy says, well, this may not have anything to do with hailstorms in my home or fire or anything like that, but it may be a risk that attacks my wealth that's invested in my home. So, I'm off property or my kids off property. That's a better example. I had this Yahoo teenager who turns around and hits somebody with a lacrosse club by accident and breaks their arm. My umbrella policy might cover that, even though they aren't even in my neighborhood at the time. Same thing's true with your professional liability risk. So that's one of it. Years ago, the docs who were doing all, and they at that time they were all he's, especially in this area, and we're on the Kansas-Missouri's borders. Kansas had very aggressive bankruptcy laws, so the docs would put all the title to all their most important property into their wife's name in Kansas. So if they ever had to go bankrupt, they could keep the property, and if they were personally sued, they didn't own the house. That sort of thing has many ramifications, including the fact that if you're in the wrong kind of state law scenario and you get a divorce, you may have lost your goods. Different state laws depend very widely on what happens if you break up. But the biggest thing you can do to help on protecting your own personal assets would be, one, stay broke. Two, that was a joke. And two, things like umbrella policies and those sorts of risk management sort of things. And keeping, if you really get concerned about it and want to drill down, consult with a local attorney and find out what assets are going to be judgment proof. In many states, if you have a home, they can't take your home, or they can't take your retirement, but they could take your personal savings. Or your investment accounts and such. So you may want to leverage things into investments in personal ownership of home, have a better home than two homes, those sorts of things.
I would
if you're
say
really
this
worried about
much more for a midwife in her own practice.
Yeah.
Not being employed by someone else, if that helps. The midwives and there are increasing numbers of midwives starting their own businesses as well as birth centers. Here's another question. Upon fulfillment of the National Health Service Corps agreement with an employer, not an FQHC, and that's true, they can be a variety of things, is one no longer covered by the Federal Tort Claims Act and therefore should renegotiate the contract? It depends on the type of entity you're working for. And that would be a question you definitely should ask before the termination of the existing agreement. Many of the contracts have clauses that actually say that you have to give them 3 or 4 months notice to renegotiate a contract. And people don't even realize that's there. It will roll over automatically otherwise. So I would just be asking that question upon an interview, or anytime you've discovered you need to ask the question. I wouldn't hold off on that one. Alvin, you want to shoot one?
Sure. So in terms of professional liability insurance, so even if we are given insurance through, let's say, a hospital system, do you recommend that we buy our own professional liability insurance? Because I carry my own as a registered nurse on top of the hospital insurance that I currently have now. So I carry both. I have my personal one and I also have the hospital one. I know it's expensive, but considering how much they can sue you in terms of a single claim, do you think it behooves us to have our own professional liability insurance as a midwife through like a Southern Cross or Covington? Southern Cross is what I'm more familiar with, but I guess any of the insurance companies could work, right?
You're going to meter that decision by what you're being offered by your employer and how much coverage is there. Like we saw one contract that's going to give 100,000, 300,000, and maybe you're satisfied with going in and doing that because you know you can get the excess coverage. And it's going to basically work in layers. So your employer's insurance company might surrender their policy limits to your private insurance company that you have, and then they take over the defense, et cetera. And you're also going to look to what that means is that with the continuity and whether or not you're escaping tail issues by having this continuous personal policy that you purchased as opposed to the employer provided policy. So you would pay, if that dovetailing of the two policies works right, you would pay, it would be a benefit to you to just have continuity of coverage as opposed to cobbling together tail and nose coverage, et cetera, because you have one consistent insurance provider anyway.
You know, Alvin, what I'm sitting here thinking about, I know Ann from Southern Cross and I know Israel from Contemporary pretty well. We've all been around about the same amount of time and have the same amount of gray hair. I don't know Coveries well, but I know midwives who use them. This is a really interesting question that I don't have an answer for, and I think it's worthy of asking them because they're going to have an answer really quick for you based on the type of midwifery practice you're doing, where you're doing it. Are you doing it in the home, in a birth center? Are you doing it in a high-risk MFM office? Are you full-time, part-time? What is their coverage? If it's 2 million, 6 million, do you really want more? Yeah. Those are all really intriguing questions that, man, I'd love to have the answers to. It's a great question.
The other thing that came to mind in answering your question would be to look to the financial viability of your employer.
What if they go under?
You choose to work with a brand new outfit. You're the third midwife of the group. They have great dreams. And then, as a small business, the odds are it's going to hit the fan. That would be a time in which you go, I appreciate what you're willing to do for me for professional liability, but I could see the scenario where that would be the one of those things like employer withheld taxes that don't get paid as a business tanks. And so that would be another thing, is to look to the viability not only of the whole scheme of the employer, who, if they're going to be able to really cover this, we think of employers as having bottomless amounts of money. Often they may be the poorest one in the scenario. We see a lot of small midwifery practices where the midwives that are working for the practice make more than the practice does. Okay. And then the companies that they're offering coverage through, are they just nonsense? And then the limits. So yeah, that would be the analysis I would be looking at in addition to what Ginger said.
So we've got one from Elizabeth. Doesn't forming a birth center business, for example, as an LLC, protect you from personal financial liability?
Answer. I can only give my clear legal answer on this one. No.
Yeah, and I'm going to say there's a lot of different ways midwives are forming birth centers, not just as LLCs. There are many options.
But my answer is still no. You have personal liability for what you've done as a professional in your professional role, in your action with the patient, and that remains there. What transfers that liability to other people isn't a full transfer, as in I'm not liable, but you share that liability with an employer. It's called vicarious liability. So the employer is only responsible financially for what the employee did and would be responsible anyway. Think the truck driver that makes $9 an hour that runs over somebody. Nobody's going to sue the truck driver. They're going to sue the truck company. But the truck driver was the one liable. The employer was vicariously liable. So you will never escape your personal liability.
Okay, she's saying personal financial liability.
Right.
Do you mean your personal family account, or do you mean personally as a business owner? I'm not sure, Elizabeth. Yeah, the words mean a lot. Personal assets.
It said the question was, and maybe Elizabeth didn't hear us.
She's saying personal assets. Okay.
Joe.
Protect you from your personal assets being touchable.
Okay. Let me reformat that. So we have, doesn't forming a birth center business, for example, as an LLC, protect you from personal financial liability.
Of your personal assets.
For your personal assets. It doesn't for your practice as a midwife, for things you did. for the liability that you owe as an employer for other people, there is what's called the corporate veil. And if your corporation is actually autonomous, and one of the ways it becomes autonomous is having insurance, et cetera, from yourself, and it also helps if there are more than one shareholder in the LLC, et cetera, then your liability may stop at the door of that limited liability company. But if you haven't run the limited liability company in a way in which it's separate and distinct from your personal financial world, or you haven't signed on to be liable by promising to be personally liable, like you do in a lease. If you go to open a birth center, your LLC is going to be on the title, but they're also going to ask you to say, I want you to promise this in person. Then if there really is a difference between the corporation and how it functions and the personal world, where you're drawing a salary and maybe a portion of the benefits from the corporation, but you're not intertwining the finances very much at all, then you have that kind of buffer that LLCs offer. Let me give you an example. I am a single attorney running a law office. There is no difference between what runs in my law office as far as day-to-day finances and what happens in our personal finances. We personally don't care if we buy something on Amazon through the office or here. We'll clean it out of the bookkeeping later for tax purposes, but it's just my pocket. I earn the money, I'm going to get to keep the money. And if that birth center is running that way for you, you're not going to have any coverage by having an LLC. So I run my office, I have an LLC or professional corporation for Booth Family Law that I almost never use for almost anything, because I recognize the fact that I'm running it so open and intertwined between that and my personal finances that anybody who wanted to would just pierce that corporate veil and run right through it.
If Elizabeth, I could offer you more conversation through Leslie Rathman, my partner, who's a past AABC president, and talks a lot when we work with people on how to decide this issue from a lens of the type of corporation and how actually 2 or 3 side-by-side corporations are more effective than one, and why. One for the facility, one for the practice, one for a foundation, and how those are completely separate legal entities. So we could give you some answers there. I'm not going to charge you anything. We'll help you out if you're interested in knowing more. I don't want to confuse you in a short answer and think it's done. That's basically what I'm saying.
Then one of the next questions we have in the queue here: if you work in a company that operates in more than one state, do you need more than one insurance policy? That would, the only concern I would see is if you have an insurance policy that doesn't cover activity in all the states you operate in. Insurance policies are governed by both state law and state insurance departments. But if you have somebody who is licensed, who's recognized as an insurance carrier in all the states you work in, you verify that the policy doesn't have any restriction for where the heck you're operating. It's what the heck you're doing.
We see that because there are obviously hospitals and clinics that operate by state, between states,
right.
on state lines. And so that's a question, again, that you just need to ask. And I will tell you, what we're learning is from the midwives who give me feedback, the more questions you ask like this in a job interview or when you're renegotiating, the more likely they are to be quite impressed that you have that level of interest and commitment to want to be part of the team. So don't be shy in asking these questions. There's a second part to that.
Ideal and safe insurance
Coverage
coverages
amounts.
In my opinion, minimum would be 1 million, 3 million. And that, remember, those two numbers represent two different things. $1 million is the maximum it's going to pay on a particular policy or on a particular claim. And then 3 million is the aggregate for each policy period, which is usually 1 year. And so you can imagine having a mother and child both having a claim, twins having claims, or just two darn things happening in the same year or three. Having that amount. I had some slides and we decided to pull them out, but common judgments against midwives are in excess of $1 million when things have gone terribly wrong in birth.
Some hospitals are now requiring 2 and 6.
Yeah, it's just a matter of inflation. But going back to the one that had 1 million, 100,000, 300,000.
I mean, we basically said to her, would you ask him if that's a typo?
Yeah.
Because that's just outrageous.
Yeah. And then you go back to Alvin's idea that if you're not satisfied with what the employer is offering, before you say, I give up, see what supplemental coverage might offer.
Alvin, we don't see or hear that much unless it's birth center midwives where they don't have high coverage rates because of cost. Because hospitals and big agencies and centers are covering probably 10 times more physicians than they are non-physician providers, and they're covering everybody, as you know. But again, asking for the policy is important, so you know what those coverage limits are.
My only concern with that is, that the hospital system, the person that they look out for the most is going to be the hospital system, right? That's really
Exactly.
the reason why I'm asking for that question, right? So while they're covering more physicians and non-physician providers, right, they're not going to be concerned about me, right, as the midwife. They're going to be concerned about protecting the marketability of the hospital system. They're going to be concerned about the reputation as a hospital system rather than protecting me as an individual provider, right? I'm the small fish, big pond, right? So that is the reason why I'm asking whether or not I want to carry my own insurance, no matter how expensive it is, right? At least I have that safety net in terms of, if the hospital decides to not go to bat for me in terms of, well, in this case, I'm assuming it's civil, right? This is going to be a civil case. And the level of proof is going to be preponderance of evidence, right? So the standard of care is going to be lower than criminal. So just to be on the safe side, I would still prefer to hold my own insurance in case the hospital decides that they do not want to go to litigation, right? In terms of, or to fight on my behalf in terms of my liability with regards to the patient.
You have a couple of things going on there. Whether or not you have the keys to the kingdom on whether to settle or not, or whether you've surrendered those to the hospital is one question. You also have the issue of one of the first discovery questions that a plaintiff's attorney is going to ask whenever they sue you is, show me your insurance policies. And then they decide who has the deep pocket. So, you do run the risk of becoming the target. If everybody else in the mix had a $1 million policy and you have 2 or 3, are you the one that's going to draw the fire? That's something people worry about a lot. And you just have to do your own assessment on risk management that way, benefit management. On the overall, the plaintiff's market is going to assume any individual, as opposed to an insurance company, is going to be more judgment proof than the institution or the insurance company. And so they're really going to try to make sure that the blame is smeared either through vicarious liability or systemic problems of policy, et cetera, where there's a direct liability by the institution. And they're going to try to spin the story that direction in order to do that, and possibly try, and the hospital's benefit or birth centers of having a continuity between all these policies is they kill that game. They're not going to have one person rat on the other person, so to speak, as well. Since the invention of the the claims reporting for physicians, the database, you also get into situations where the physicians don't want to settle because they don't want to have a claim against them. So they'd rather have vindication, even though they're willing to ride it all the way up the pole, because they don't care if the insurance company pays twice as much. Because they just don't, their ego can't take the hit of having a claim in the database kind of thing. So there's all those games that also kind of fold into this, that become something of interest. So there, I suppose there's a theoretical risk to being overinsured, but if you're overinsured, you've just insured against the theoretical risk. So you have this.
You know, Alvin said something that I think.
Can't you mitigate that by carrying a policy that is equal to the policy that the hospital is offering you? So then there is no, your policy is greater than the hospital policy, right? So then
as long as one isn't above the other. As long as, let's say you have a 1 million, 3 million policy and your employer offers a 1 million, 3 million, but your 1 million, 3 million won't pay out 1 million in $1 claim. So yeah, it's like almost like the uninsured motor vehicle kind of thing, where you're only going to get paid if there's a gap in the coverage in some other place in the world of insurance.
The other thing you said, Alvin, that I just like, oh my gosh, he just said something really important. And I think we may have said it once, but I'm going to say it again. We have seen some contracts where midwives are asked to surrender the settlement of any claim exclusively by the employer.
Yes.
Which means you've given up any and all rights to be engaged or say yes or no, fight or not fight. Really, really important clause. So that could tag on to what you're saying right now. That would be important to.
No pun intended, Alvin.
You know.
Yeah.
Be important to figure out.
Yeah, it's a rare clause, but basically it creates the liability that throws towards you, especially in settling a case. If 3 docs own a practice and have hired 1 midwife, and the midwife and the docs were involved in a birth and it went bad, that's an ideal situation in which the midwife's policy is going to get drained first, because they have control over that. Even if you were out, you were in the lobby having a Coke during the birth, you're going to wind up being tanked because they're going to do a settlement agreement that says draw on the midwife's policy, leave our policies alone, so we're not in the database.
Okay.
So we really, when we see that in an employment agreement, we're real careful to go, no, we want to be in control of our own choices.
Yeah. And my deductible is the one that increases at the end of the day, not the obstetricians, right? So that's another problem, right? If I get sued and then I get deducted, then my insurance policy is going to have a higher deductible because I've already been sued once, right? So that's another consideration, right?
Well, you also have just the plain fact that as you track things like the databases, your marketability reduces, and that's what the doc is worried about. They're not worried about how much was paid to the injured party. They're worried that they're squeaky clean on their marketability.
Well, I'm worried about that too as a midwife. I have a reputation to pay myself too. Like I would like my patients, I would like to get more patients, right? In terms of my contribution to the practice. So yeah, doc's reputation is important, but my reputation is just as important as well, right? So I you that point, actually.
You see it all the time in the news, whether it's the contemporary one talking about police officers and whether or not they've had prior disciplinary actions when you criticize what they did today, or whether it's the Me Too movement with people who had previous complaints, or whether it's professional liability, anything else, that record carries forward, even though it's not good evidence. Just because somebody burglarized 2 places doesn't mean they burglarized your house. But it carries over and it operates to who the hot target is and your professional reputation. And what those kind of clauses do is simply surrender that professional goodwill to somebody else's decision making, and we don't like those.
And how is it normally worded in the contract if they're asking you to surrender the goodwill to, like, so the plaintiff or the employee will surrender said like rights to litigation to the
Words
hospital
like
or to the employer?
the midwife agrees to indemnify and hold harmless the practice for any claims, and words like should there be a claim, the practice has the sole decision-making power on how to proceed with managing that claim.
Okay.
Those two. And the easiest one to miss is this idea. It's really interesting. We have some contracts that we've seen in which the midwife takes this larger amount of money that they're generating, let's call that $300,000 a year, for a $90,000 a year salary, and then turns around and is asked to guarantee against all employer risks through indemnification clauses for the cost of doing business. Well, you already paid for that. You gave him $200,000 for that.
Mm.
What Joe means is if you look at the profit versus the cost, most midwives full-time, if you do a pro forma, and we do quite a few of these, are going to profit a physician or a hospital practice full-time, full scope, $300,000 to $400,000 a year.
Mm-hmm.
So subtract your salary from that,
And some benefits.
and benefits, 30 to 40% benefits. They're making a lot of money.
Yeah.
And they're still asking you to pay for things that make no sense in relationship to the salary that you've agreed to.
Most of these contracts, and we'll close with this, that we see between entities that hire midwives, especially, have been borrowed from the older days of medical MDs and DOs, et cetera, physicians working within a practice. And in those contexts, the care provider was making a commensurate amount of money as the entity. So you have two almost equal footing kind of people. You got a physician that might be pulling down $400,000 or $600,000 a year. Sharing liability makes perfect sense in those contexts.
Mm.
You pick up that contract and you move it over into a midwifery situation, and they think they're hiring a nurse on steroids who can do cool things, and paying them $100,000 a year, and then expecting that same risk spreading. The economic theory is broken. Is my little tom-tom.
It's a negotiation point.
Yeah.
Well, that's where you have to outline your duties, right, very clearly before you enter into a contract with.
You would hope they would do that, Alvin, but they do not. Most of them do not, which is one of our comments to people is, you're going to work full time. Well, isn't that great? What does that mean? Yeah. And if there are 5 midwives in a practice, and 2 of them get pregnant and 1 breaks her arm, are you picking up all the extra coverage time for no pay? Yeah. In the theme that it'll all work out later. I promise you it will not. So it's really important to think about that. I do want to point out these resources, and then we'll end with this last question. We have a lot of free webinars on our website. We're transitioning over to a new company, but they're all there. 2 years worth of webinars. We took a hiatus for a while, and now we're going to start ramping them up again. In a month or so, we're going to do one on how to land your first job. Joe and I put together a vicarious liability toolkit. Joe wrote the last peer-reviewed publication for the Journal of Midwifery and Women's Health about 10 years ago. And we took that and brought it up to date, far beyond what the journal would allow published size-wise. So we created our own toolkit that could be of interest to you. Of course, we do services of consultation, and ACNM has a professional liability handbook. I will say it's a bit dated. I think it's 2014, but it does have some information, kind of like anatomy and physiology concepts that don't change, but it's probably not as contemporary as it should be. So there's one more question.
Oh, sorry, Ginger. I tried to find that ACNM liability handbook, and then was having difficulties finding on the website. So I don't know if they're in the process of updating it or something, but it was
You know,
not.
we're updating the service
Emily has
director's
an answer.
manual. Somebody has an answer?
I'm on the publications committee. It's being updated right now and should be out for this year.
Awesome.
There you go.
And I didn't add the new business director's manual should be coming out in October as well, right, Emily?
Yes, although COVID has thrown a curveball in all of this, but yes.
And that would be equally valuable to anyone trying to learn a lot of these concepts. They are great resources.
Elizabeth had a question to everyone, so I think it's fair to read it out loud. Calvin will like it.
Poor Alvin. Unlike Alvin, I do not have a law degree, and I find the lingo very difficult to understand. Who do I go to revise the malpractice insurance my employer will provide? Do I have to hire a lawyer to review it, and how much will that cost me?
It's a multifaceted question only in this sense. If you ask your potential employer to show you the policy, then you could actually talk to the insurance company and understand more about the coverage they're actually offering. If you're negotiating with an employer, you can either equip yourself through various resources, and including talking to people like Ginger on how to negotiate more effectively, or you can have local counsel to represent you in the formation of an employment contract. So you can go at that in 2 or 3 different ways, or all of the above, or just hire Alvin.
No, it's a minor in law, so I would
Yeah.
say
Oh, we're just having so much fun at this point.
I am so thrilled. There's the
the
male midwife. You have no idea. I hope you've, found other contemporaries, many of them retiring now, that have been male midwives for 30 and 40 years.
I've talked to some of them, yeah, but it's very rare now, very few now.
I know.
Ginger shared a long-lasting relationship with a fellow ACNM board member.
Michael McCann,
Yeah,
out
it's
of
wonderful.
Georgia. A couple. But anyway, thank you all for joining us. We really appreciate you being here, and we look forward to much more interactive midwives with their employment contracts, and ramping up the profession and getting what we deserve. We've got some ways to go, but we can do it. Thank you all.
Bye.
Thank you very much.
Yeah. Bye-bye.